Hi, could you please state your name and the position that you're seeking?
My name is Paul Belew, and I'm seeking the district court nomination for the Wise and Jack County District Judgeship.
What qualities do you have which you believe will make you the best district judge?
Well, over my 30 years of experience, at least I've calculated about 200 jury trials, many of them here. I do travel to Tarrant County, Denton County. I've been involved in the mental health caseload here. Uh, Practically know uh, everyone in the county, a lot of people in Jack County. We only have docket in Jack County the first Friday of every month because it's a smaller county. However, at one time, I was probably the only lawyer trying cases in Wise County. I tried 7 in 1 year just because I believe my experience, Judge Fosdell, God rest his soul, Judge Smith has been great to me. They give me some of the harder cases, especially when the mental health caseload. And so I believe my experience here, I'm at least 4th or 5th generation Wise Countyan. Some people say that's the good old boy system. Actually, the good old boy system is probably 20 years older than me, but I think I think they support me just because of my deep roots here and my commitment to the community.
How do you perceive your experience compares to that of your opponent?
Well, first of all, Andrew and I are friends. And so it's very difficult to dance around certain subjects. And so Mr. Lloyd is primarily from Denton. Hey, he does reside here. I think he bought his home in 2019. Great guy. His experience, I think, is mostly in family law and mediations. He did start taking criminal defense cases here. Uh, my experience, though, I've never seen him try a case here or anywhere for that fact. I know he was a former prosecutor in Denton, and I'm not knocking his experience, but my experience in the courtroom is so much more vast. I've been through Judge Fosdell, through Judge Smith, through Judge Lowry, uh, just through God rest Judge Cood's soul. You know, I've been through his court, the JP courts. I just have so much courtroom experience that case in chief. You know, I recently tried a case in Wise County, a DWI case, and I can't talk too much about it. It's on appeal, but I lost. And one of the jurors contacted me and said, "Mr. Blue, I know you lost your case, but I want to hire you for my son's case. I was so impressed with the way you spoke to us." And so I believe that will translate into not being soft or, uh, easy, but I think that translates into experience for the bench.
Can you describe a time when you had to make an unpopular decision based solely on law?
Yes, absolutely. People will look at this funny. Not to be, I don't want to sound condescending, but people that are not in the legal profession sometimes do not understand the role of a defense attorney. And so the defense attorney is to advocate for the client. And the judges obviously go by the rule of law, but the defense attorneys try to twist that and manipulate certain things. So the most unpopular thing that has ever happened to me was a win in Dallas County in front of a liberal judge. It's been about 15 years ago. It was regarding bond conditions. And I argued to the judge that his bond conditions were contrary to the Constitution. They were unconstitutional as being too restrictive. It went up to the Court of Appeals, the Court of Criminal Appeals, and they sided with me. And they let the gentleman go without bond restrictions. Now, saying that, this person was charged with a very heinous crime. The legislature was meeting that year. They closed that loophole as soon as it opened.
What is your philosophy on bail and pretrial detention under Texas law?
Oh my gosh. So our jails right now, it's hard to say with what the population of the jail is right now. But they have passed new laws where certain people are not eligible for bonds. Certain heinous crimes, such as murder, the judge has discretion whether to no bond somebody. They have a right to a hearing, but there are only certain cases that a no bond can be held. Pretrial services is very popular in Tarrant County for first-time nonviolent offenders, where they pay $25, they get out of jail, they report weekly to a pretrial officer. What we have here in Wise County, we have the bail system where attorneys can bond, but also the bail companies can bond as well. And so it can be oppressive in that if somebody can't afford bond, then they stay in jail. And then with the backlog of cases we have, and it's not really due to anything other than the unprecedented growth that we've had. Whoever takes office is going to be literally deluged with a cluster of things to deal with. And bail and bond is certainly something they're going to have to address. I feel that the Constitution and the rule of law dictates certain areas of the bond, but also the legislature has set out rules that limit what the judges can do now on bond.
How will you ensure that every litigant, regardless of background, wealth, or representation, receives a fair hearing?
So that goes into another area I'd like to talk about. We do have the Indigent Project in Texas, where if you cannot afford an attorney, you can be appointed an attorney if you ask for one. The U.S. Constitution, believe it or not, only says that if you're indigent, you only have a right to a competent attorney. That can mean that you're charged with, say, second-degree manufacturing drugs, and you get appointed a family law attorney. That has happened to me, where a young lawyer is a little bit over her head in the case. Judge Smith co-appointed me to help out to ensure that gentleman gets my experience and knowledge of the legal system to ensure that he gets a fair and impartial trial. And that's not a knock on the new lawyer. It's kind of a mentorship. And so the courts are open. The courts are very backlogged here in Jack County because of the FedEx Athena Strand case. And as we all know, that's a death penalty case in Tarrant County, and it's taking resources away from Wise County. But the courts, they have a docket system that needs to probably be revised. And I think we all can get together with the DA and the people together and resolve that docket issue.
How do you balance the letter of the law against the perceived spirit of the law when you're rendering judgment?
Now, so as a judge, you take a different oath than I take. So as a defense attorney. So the rule of law is the only thing that matters. The Constitution is the only thing that matters. Is my example before where I made new law, that was my exact argument as a defense attorney. I argued the spirit of the law says this. The legislative intent says this. Judge, it is highly restrictive and prejudicial to the client. The legislature intended to do this. The judge made probably an erroneous decision as the legislature closed that. So there are opportunities for defense lawyers and state to argue intent, legislative intent. The spirit of the law, judge, does not include this. The judge's role is to enforce the rule of law as it's written by the legislature and the Constitution, with no exceptions.